Hi, good afternoon. My name is Allison Roach, and I'm a labor and employment attorney in Schoeneck King's Buffalo office. I'm happy to be with you here today to discuss how institutions should be consider balancing pregnant students' rights with academic program requirements. I'm presenting today with my colleagues, Jane Sovereign and Dr. Barbara Lee, both of whom have a wealth of experience advising higher education clients and thinking through these types of issues. Next slide, please, Kathy. So as I'm sure you're all aware at this point, the new Title IX regulations emphasizing the rights of pregnant students may pose new challenges for institutions of higher education. So for our presentation today, I'm going to start by presenting a very brief overview of pregnant students' rights under Title IX. I'm going to endeavor to keep this part of the presentation as short as possible, just because I think most on the webinar are already aware of the basics, but please note that we will make the slides available after the presentation. So if you feel that I'm going too fast or you missed something, again, we will make that information available to you. And then after covering the basics, I'll discuss some of our suggested best practices. And then I will turn it over to Barbara and Jane, who are going to apply these suggested best practices to a series of hypotheticals so that you can begin to think through the framework that we suggest applying to requests for accommodations. We're also going to allow you to submit questions if you have any during the presentation. And as Kathy noted, we'll monitor the question box. And then if we have time at the end, we'll try to answer the questions that we think would be most relevant to the wider group. And then, of course, if you have any questions that would be better answered offline, please do not hesitate to reach out to Barbara, Jane, or me. Next slide, please, Kathy. So as many of you are likely aware, there have been some recent injunctions that have prevented the Education Department from enforcing the new Title IX regulations in many states. Specifically, the Education Department is currently enjoined from enforcing the regulations in 26 states, which is affecting hundreds of institutions of higher education. So as a disclaimer, all of our hypotheticals here assume that the school is in a state where the new regulations are in effect. And so, of course, this presentation applies directly to those remaining 24 states. But with that being said, even if your institution is in one of the 26 states that are subject to the injunctions, we do think that the presentation today will be worthwhile for you because we do expect that some version of these regulations applying to pregnant students will ultimately apply to every institution in the future. We think this because the new regulations related to pregnant students are some of the least controversial, and there does appear to be some level of bipartisan recognition that helping pregnant students leads to positive outcomes. Next slide, please, Kathy. So very basic on Title IX protections for pregnant students, but it prohibits and protects students from sex discrimination based on pregnancy, childbirth, termination of pregnancy, lactation, or related medical conditions. And it also prohibits and protects students as they recover from pregnancy, childbirth, termination of pregnancy, lactation, or related medical conditions. Next slide, please, Kathy. So we've included here, as you can see, there are many examples of related medical conditions. This slide provides a non-exhaustive list of these conditions. And then also please note that the preamble clarifies that discrimination based on menstruation, perimenopause, menopause, and related conditions also constitutes prohibited sex discrimination. Next slide, please, Kathy. So Title IX protections for students. If an employee of a higher education institution is informed of a student's pregnancy, they must provide the person with the Title IX coordinator's contact information and must inform the person that the Title IX coordinator can coordinate specific actions to prevent sex discrimination and ensure that the student has equal access to education programs and activities. The institution must inform the student of its obligations and provide a notice of non-discrimination to the student. And likewise, information about a student's pregnancy must be kept confidential. Next slide, please, Kathy. So here we have some slides on reasonable modifications. The institution must make reasonable accommodations to its policies, practices, and procedures as necessary to prevent sex discrimination and to ensure equal access to educational programs and activities. These modifications have to be based on the student's individualized needs, and institutions should consult with the student to determine what modifications are required. However, please note that a modification that the institution can demonstrate that would fundamentally alter the nature of its education program or activity is not a reasonable modification. Next slide, please, Kathy. The student has discretion to accept or decline each reasonable modification offered. Of course, if the student accepts an institution's offered reasonable modification, the institution must implement it. And then we've listed here just some modifications, for instance, breaks during class, intermittent absences to attend medical appointments, access to remote education. Next slide, please, Kathy. And then this non-exhaustive list is further listed here. You can see changes in schedules, extensions of time, counseling, changing physical spaces, elevator access, and just, various other changes to policies and practices. Next slide, please, Kathy. The institution must allow a student to voluntarily access any separate or comparable portion of the institution's education program or activity, provided that the separate portion is comparable to that offered to students who are not pregnant and do not have related conditions. Notably, the institution may not force or pressure a student to participate in the alternate program, and students have the right to stay in their same classes or extracurricular activities. Next slide, please, Kathy. In terms of voluntary leaves of absences, the school must allow the student to voluntarily take a leave of absence from the education program or activity to cover at a minimum the period of time deemed medically necessary by the student's licensed healthcare provider. And then to this extent, a student qualifies for leave under a leave policy maintained by the institution that allows a greater period of time than the medically necessary period, the institution must permit the student to take a voluntary leave under that policy instead, if the student wants to do so. And then when the student returns to the institution's program or activity, the student must be reinstated to the academic status and, as soon as practical, to the extracurricular status that the student held before the leave began. Next slide, please, Kathy. In terms of lactation spaces, the institution has to ensure that the student can access a lactation space, which must be a space other than a bathroom that is clean, shielded from view, free from intrusion of others, and then that may be used by the student for expressing breast milk or breastfeeding as needed. Next slide, please, Kathy. And then here's just some of the requirements for supporting documentation. The institution may require supporting documentation for the need for reasonable modifications or for voluntary access to separate portions of programs or activities, voluntary leaves of absences, or also for requirements of lactation spaces, as long as the documentation is necessary and reasonable for the school to determine the reasonable modifications. And then we've also provided below just some examples of when supporting documentation would be unnecessary. These are pretty obvious, but just, for instance, like the need for a larger size uniform or allowing breaks to sit and stand or to use a bigger desk. Those are really instances where supporting documentation would be unnecessary. Next slide, please, Kathy. And then in terms of comparable treatment to other temporary medical conditions, the school has to treat pregnancy and pregnancy-related conditions in the same manner and under the same policies as any other temporary medical condition with respect to, healthcare benefits or, other programs that are offered with respect to other students. Next slide, please, Kathy. Certification to participate. So the institution may require a student who is pregnant or has a related condition to provide certification from a healthcare provider or any other person, stating that the student is physically able to participate in the institution's class, program, or extracurricular under a few situations. So first, the certified level of physical ability or health is necessary for the participation in the class, program, activity. or the institution requires certification of all students participating in the class, program, or activity. And then it's important to note that the information obtained should not be used as a basis for discrimination that is prohibited by the Title IX regulations. Next slide, please, Kathy. Okay, so now that we've covered the basics of how the new Title IX regulations apply to pregnant students and their requests for accommodations, I'd like to now discuss some of our suggested best practices for institutions. So first, we recommend that institutions consolidate all of their pregnancy and lactation policies into a single standalone policy, if possible. And this is really for the benefit of both the school and the students. It's simply much easier to refer students and staff to one clear-cut policy, which sets out all the information in one place. And then if you have to make revisions, there's just one policy that you need to revise and redistribute. Second, we recommend that you consider a team approach to discussing academic accommodations. So basically, that means that when a request comes in, either from a faculty member or either to a faculty member or the administration, then that request can then be forwarded to a team of individuals who can help determine and assess whether the requested accommodation is possible. So obviously, this will likely include input from an affected faculty member throughout the process if the accommodation relates to the faculty member's course or something like that. But we do think it's preferable to have a team of individuals who work through these issues on a more regular basis. And similarly, we suggest that you form this team now and discuss your process so that you aren't scrambling when you receive a request for accommodations. Third, we suggest that the final decision maker for academic accommodations be a dean or provost as opposed to an individual faculty member. Fourth, for programs leading to licensure like nursing or other healthcare related fields, we recommend that you check on time restrictions with the licensing agency to see if there's any flexibility possible under extraordinary circumstances. It's really better to check in and work with the licensing agency or the licensing department whenever possible, just rather than simply taking these time or licensure requirements at face value. Our fifth suggested best practice is to never say never. Basically, what this means is that many of you have very large institutions with various types of academic programs. And so it's best not to assume that an accommodation would never be possible. And we really recommend trying to avoid stating that a modification could never happen. Instead, we recommend approaching students' requests with an open mind whenever possible. And this advice really flows into our next suggested best practice, which is to determine whether the requested modification or accommodation has ever even been provided to a student, even if it was many years ago. So again, this is where having a team approach can be very helpful, particularly with respect to institutional knowledge around such issues. It's important to check and see whether this modification or request has ever been provided, particularly in light of the COVID-19 pandemic or any other extraordinary circumstances. Seventh, if leave is the best or only reasonable modification and the student requests a tuition refund, we recommend considering offering a tuition credit for future semesters instead. And then finally, while of course the ultimate decision on reasonable modifications belongs to the institution, it's really important for institutions to take student requests seriously. The way that we read the regulations is that they are very pro-student. And it seems to us if there's a request for accommodations, even if it might seem ridiculous or infeasible on its face, the institution will still be expected to work through the process of assessing the accommodation in good faith. And so now with that, I'd like to turn the presentation over to my colleagues, Jane Sovereign and Dr. Barbara Lee, who are going to put these suggested best practices into action. So Jane provides legal advice and counsel to colleges and universities, independent schools, and public school districts on all aspects of education and school law. And prior to joining Bond, she served as Deputy General Counsel, Interim General Counsel, and Vice Chancellor for Legal Affairs at CUNY. And Barbara provides higher education to clients in all aspects of education law. And prior to joining Bond, Barbara was Senior Vice President for Academic Affairs at Rutgers University, where she continues on as a Distinguished Professor of Human Resource Management. Barbara is a former director of NACUA, and she's a regular speaker for the organization. And she's also co-authored one of the most recognized treatises on higher education law, The Law of Higher Education, and has been a prolific author of hundreds of articles on employment law and higher education issues. So now at this time, I will turn the presentation over to Jane and Barbara. We're going to apply our suggested best practices to a series of hypotheticals.
Thank you, Allison. And next slide, please, Kathy. Thank you very much for the kind introduction. It's nice to see so many people here to kind of think through these issues with us. I see on the list of people, former colleagues, clients, friends. It's great to have so many folks thinking about this. Let's start with the first hypothetical, and obviously these are not based on specific people, but may resonate with some of you that you've seen things like these. So a doctoral student has completed all coursework and will be defending her dissertation in April. The graduate school requires students to complete their doctoral program within 7 years. The student is scheduled to defend in late April, but her baby is born 2 days before the scheduled defense, and the student is medically unable to defend her dissertation until after the expiration of the 7-year period. With starting out with the point that can't be overemphasized, which is all of these situations are going to come to you with their particular facts, and that these truly are going to be case-by-case decisions. But without having right or wrong answers here, I think we can talk about some questions that we can ask to help dig into this. What if you learn that the graduate school has waived the 7-year deadline twice in the last few decades, both times because the student's major advisor, the faculty member, has been temporarily unavailable because of health reasons. And that's something that certainly you would want to think very carefully about if the school had essentially given an extension of the 7-year period or a waiver, an accommodation because of faculty medical issues. I think that puts the student's request into a little bit of a different place, whether students' medical issues would be as necessary to accommodate as faculty members. It's one of the most important questions to ask when you're going through these really right at the start is, what is the purpose for this 7-year deadline? Is it related to making sure that coursework and research are up to date? Are there other reasons for it? And I think that's going to be very important to know in order to see how the student can be provided modifications. Are there any that could possibly be provided, including this request to modify by extending the timeline? And you will want to know how much additional time the student would need to complete her program. Considerations that tend to come up in almost all of these are, would making an exception sort of create a push from other students to extend their deadlines even without health-related reasons. And if that's something that you have real thought that may happen, or in fact you had seen it happen, that would be something to consider as you're looking at what the reason for the deadline is. Is this something that is really causing great difficulty for a lot of students for a variety of reasons? This would be something I think that the program would want to think about. And certainly it would be something worth considering, starting a practice with this student, given that you have incidents of waiving the deadline for faculty members. You might want to consider evaluating any request for extension of the deadline for extraordinary circumstances on a case-by-case basis. So a lot to think about with this one. Kathy, next slide, please. So the second hypothetical deals with student teaching. And the student teacher is scheduled to begin her student teaching in September. She discloses her pregnancy just before the start of the school year in September and is scheduled to deliver in late October. And the college's program, and let's say here, the state licensing requirements provide that the student must teach for a full academic semester. So could there be if the student is asking, say, for a reduction in the amount of time that she spends teaching, can I only teach up to the point where I deliver, and that's what the modification that I want. And in considering whether that's a reasonable or even possible modification, we'll need to dig into a number of issues. Of course, the state licensure rules. Perhaps the academic semester, looking closely, is this a semester? Is it a number of hours or days or weeks? So kind of really getting very detailed about the licensure requirements. As we noted in the suggested practice guides that Allison went through, it can be very helpful to take an early look at what the licensure requirements provide if you think there are going to be requests, if there have been in the past or maybe requests now, because the more you know and the more lead time you might have to look into this, I think would be helpful in dealing with a request of this kind. Then trying to think of alternatives. Could the student split this, even if a certain number of weeks or a semester has to be done, that is longer than the time that the student would not be able to do given the pregnancy, could the teaching be split over 2 semesters with time in between? Is that possible for the student to return to complete it? That's a question that may involve both, the licensure requirements and a school district where the student is going to be doing the teaching. And there may be school districts, possibly because of licensure, possibly because this is how they do this, and that it's only on a semester basis and nothing else. So you know, there, some of the issues to think about are, can the university require the student to take a leave until the following fall? Some students may be eager to do that, may ask for that. Some may be very concerned about completing their program, about the tuition they've already paid for the semester, and so forth. But certainly a leave in many, if not most cases, is almost always a reasonable modification depending on all the facts and circumstances. So while you're thinking about whether the student may have to take a leave essentially of almost a year, but has there ever been any situation at the university where a student took leave during their student teaching experience for a medical or mental health reason? Because again, if that's ever been allowed, now the student may have been required to go on a leave of a year or what have you, but if there's been some kind of accommodation for a medical or mental health issue, it would be very hard to argue that this wasn't similar to that. Again, depending on the particular facts. So has the university ever provided a kind of segmented or shorter opportunity for student teaching? And did that work with licensure? If the sort of back to the district, because we know that some of the most difficult issues with these situations, particularly when there are clinical rotations or student teaching, where the student teaching in this case happens at an institution that you don't control. And so if the institution says, no, we are not going to do this, and you can't make them do it, then it's still important to try to see if there are alternatives for a number of reasons. And that was one of the pieces in the practice guide, the suggested good practices that Allison went through. It's really important to do as much work as you can to explore all options, really for a number of reasons. One is one of them might work. You might find something, and don't be discouraged. We really encourage you, even if 5 years ago you called all the other school districts and they all said no. Well, 5 years is a long time. Things have changed. Maybe a district would be willing to do that now. Also, you're showing the student that you're working to try to, if this is a student who really wants that opportunity to be able to have a segmented or short, student teaching because she's very concerned about length of time, money, graduating, being able to start earning, and so forth. You're showing that student that you're really trying to make this work. If the opposition to this, the roadblock, is at the district, and it sort of kind of, should you end up unhappily being the recipient of a complaint by the student to OCR or an OCR investigation or any other kind of complaint, it may not win you the whole case, but certainly being able to show and document that the program really tried to explore alternative options if the student's strongly preferred option was not a possibility. I think that's always a better position to be in than we told her, nobody ever does this, don't even think about it, sort of get ready and take a leave. So, next slide, please, Kathy. Thank you. So the third hypothetical is somewhat similar in that we have a student in a physician assistant graduate program who needs to successfully complete 3 rotations to graduate on time. And her medical provider, she's submitted medical information that said she can't lift more than 10 pounds and must not stand for more than 10 minutes at a time. Her remaining rotations are pediatrics, surgery, and orthopedics. And these rotations are each 8 weeks long. And the student is scheduled to deliver halfway through the 3rd rotation. And that 3rd rotation won't be available again for 11 months. Do these requested modifications prevent the student from fulfilling professional requirements? That's really the overarching question. So some parts of what you will want to look at to be able to consider this is, are there other responsibilities? Is there a way to allow her to provide to get similar skills and knowledge in a way that doesn't require her to lift and stand at these levels? Are there other parts, other skills of a PA that could be substituted here? Would providing these modifications, and this is so often a question in these kinds of clinical or student teaching situations, would allowing those modifications make the student ineligible for licensure or for professional employment? And obviously, if that's the circumstance, that's that's certainly something that the school will need to consider. And that is a strong interest that the school may have. Again, as we talked about before, understanding the details of the licensure requirements, understanding if there's any possibility for extraordinary waivers that the licensure agency allows. Some of the things you could also think about if you're at a roadblock here, would it be reasonable to request the student have get a second medical opinion that is at the school's expense, to see if these are ironclad, absolutely appropriate, medically appropriate requirements for this particular student with her particular situation. If the student did not want to get another opinion, depending on your policies, it might be difficult to require her to do that, but it certainly is, could be an option that would be worth thinking about. If you can perhaps still make this work for licensure, make this, if you've kind of overcome perhaps these roadblocks again, what about if the institution, the participating site, refuses to allow the student because they say this would compromise their standards of patient safety, or they may have regulatory requirements or insurance requirements that are a hard no for them. And in that case, again, I think you would want to look at other sites, ask about, keep looking into is there sort of a comparable experience that could give different schools? And then the student could do some of these later. Could you even consider something if their students go by cohort for their rotations? Could you switch the student to an earlier cohort, or is there any wiggle room with the timing so that perhaps there might not be an 11-month gap, it might be a shorter gap? Again, you may have to end up with and that really the only accommodation you might be able to give is leave. But again, whatever you can do to explore all options and really sort of drill in as much as you can, that's all very important as well. So now I'm going to turn the mic over to Barbara Lee with some additional hypotheticals, and then we'll get to some questions, hopefully.
Okay, thank you, Jane. Before we move on to the next hypothetical, I'd just like to reinforce something that both Allison and Jane have said. And I'm sure it's become obvious so far during the webinar. The process that you go through is incredibly important if you are unfortunate enough to have an Office for Civil Rights complaint filed against you. They will not only look at the decision that's been made, but the process that was gone through to make the decision. And one of the very important points that OCR has made in the past when they've been opining on a student complaint about an institution's alleged refusal to provide a reasonable accommodation, they have said that the decision, and this was in our best practices list earlier in this webinar, should not be made by an individual faculty member. It should be made by a group of people. And I'd like to read you actually just a couple of sentences from, and I'm going to give you the citation. It's an OCR complaint number 01-16-2120, which is on the OCR's website. And it was a complaint against, because these are all public documents that have been heavily redacted, the University of Massachusetts at Boston. So you can find that case. And I think the language is really very important, talking about how an institution makes a decision about a fundamental alteration or a required academic requirement that the student must complete. It says the requirement should be essential to the educational purpose or objective of a program or a class. The OCR policy requires, among other factors, that decisions regarding essential requirements be made by a group of people who are trained, knowledgeable, and experienced in the area through a careful, thoughtful, and rational review of the academic program and its requirements, and that the decision makers consider a series of alternatives for the essential requirements, as well as whether the essential requirements in question can be modified for a specific student. OCR affords considerable deference. After saying all that, then they say OCR affords considerable deference to academic decisions made by post-secondary institutions, including what is or is not an essential program requirement. So clearly the process that we go through in trying to determine how and whether we can accommodate a pregnant student is pretty much the same as the process that we would need to go through in dealing with disability accommodations, and the interactive process, as you know, is critical. When they do warn against letting an individual faculty member make this decision, and they say some things which, as a faculty member myself, I might find a little offensive, but nevertheless, this is what OCR said. Professors do not necessarily have specialized training in the law or disability issues to make informed decisions about what is legally required by Section 504 or Title II of the ADA. Thus, leaving students to negotiate with their professors to obtain accommodations compromises the interactive process, which is further compromised because of the disparity in power and authority between a student and a professor who ultimately assigns the student a grade. So you can see where OCR is coming from in their approach to disability accommodations. And My guess is that they would follow an identical or similar process with respect to pregnancy accommodations. So let's do another hypothetical. Next slide, please, Kathy. So this is a student who is majoring in dance, and she is pregnant, and her healthcare provider has said that she cannot run or jump during her pregnancy, which would make it difficult to do some dance things that she otherwise would be required to do. And the curriculum does require her to run and jump. She's just gotten an internship with a dance company in New York City, and it's a 6-month internship, and she's nearing the completion of her second trimester, which means that the baby would be born in the middle of this internship. So we have a number of complications, let's say, in this situation. So my first question would be, does the curriculum require an internship? All right, if it does, then you have one path you need to think about. If it doesn't, if it's a nice to do but not need to do situation, then you may make some different decisions. So certainly that's an important issue. Let's assume that the internship is required just to make it a little bit more difficult. Can the institution ask the student to get a second opinion about the running and jumping? Even if perhaps the institution agrees to pay for it. That might help resolve the problem right there, or it may not. Another issue would be, will the internship site permit the student to participate in the internship because her doctor has told her she cannot? And that would be a decision that the internship site would make, but certainly the institution would have the responsibility to have a conversation with the internship site to see if they could work out some sort of a reasonable solution. Also, if the curriculum requires an internship, then the options are more limited. You might want to know whether the internship site would allow the student to delay the internship until a date that her doctor says is safe for her to participate, or until after the baby is born. And what if the institutions or the internship site withdraws the internship offer? Then what is the institution's choice at that point? Well, are there other internship sites that the institution can contact on the student's behalf, or perhaps she can contact them on her own behalf and discuss whether or not the requirements of the internship would accommodate her needs before she has the baby. Another option could be a leave of absence, and that is usually an option in these cases, but frequently, or usually, probably, hopefully not the only one that's offered to the student, but sometimes that is the only feasible option. Or then could she return to the program after the baby is born and she's been medically cleared with no additional tuition cost? And I know the tuition issue is a sensitive one for all of us, but I like to use the example of giving a student an incomplete, which some of my students need incompletes at the end of a semester because they don't get their research paper finished in time. And we have an opportunity to give them an incomplete if they complete the assignment within the next semester, but we don't charge them additionally for the following semester. They complete the work the following semester and they get their grade, hopefully, and that's the end of it. So that's something to think about with respect to the tuition issue, because students often ask for either a tuition refund or an opportunity not to pay tuition when they continue the program that was interrupted because of the birth of their baby. Okay, next slide, please, Kathy. All right, this I think is an extraordinarily difficult situation. I hope none of you have to deal with it. And but I think it's a possibility when we have women, particularly graduate, well, not necessarily only graduate students, but more likely to be a graduate student because they would be more likely to have more significant responsibilities in a science lab or a medical lab. And this particular student is a research assistant in nuclear medicine, and she's the top advisee of the head professor of the nuclear medicine lab. So she's very advanced. She's very important to the success of the research that's done in the lab. Her healthcare provider has said she cannot be exposed to radiation in any form while she's pregnant, and she's 6 weeks pregnant, so she's going to be pregnant for a while. Some of the equipment that the student has to work with emits small amounts of radiation, and patients that she works with also emit small amounts of radiation right after their treatment in the lab. And her role is central to research grants that her major advisor has obtained. So she's an important actor in the research that's going on and in the work of the lab. And she's just found out she's pregnant. So what to do? Well, it's pretty much black letter law that with respect to accommodations for disabled employees, the institution doesn't have to create a new job for that individual. But is there a position that would benefit the institution and also provide an appropriate learning experience for the student? Is there something is there money in the grant, for example? Maybe not, maybe there is, but that is something that the institution could consider. And have there been positions in the past that don't involve radiation exposure that could be regenerated and she could do for the duration of the pregnancy? Would the student be willing to get a second opinion about whether exposure to a very low level of radiation would be a problem for the developing baby? That might not require a medical exam. It might just require a scientific opinion from some other expert other than her major advisor, who may be minimizing, maybe not, the danger to the baby. And if the student discovers protective equipment that would reduce her radiation exposure, does the university have to buy it? Well, then we go through the undue hardship analysis, right? The same way you would with an accommodation that may be expensive and may not be expensive, but it would be important to find out what the cost is, and even more importantly, whether it will work, whether it will protect her and her baby during the time that she's in the lab. Could this equipment be used by other students or other employees in the lab when the pregnant student is not using it? In other words, could there be a broader benefit to getting this kind of protective equipment, not just for the student, but for others? Certainly, radiation exposure may be a concern of other people as well as this particular student. And lastly, is there any safe time in the pregnancy when a student can work in a situation where she's exposed to radiation? Again, I don't have medical knowledge, but hopefully someone at this institution can opine or find out about maybe later on in the pregnancy, the risk is much lower than it is early in the pregnancy when the baby's brain is developing, for example. We don't know, I don't know, but that would be a question that would be appropriate to find out. So again, process is incredibly important. Clearly documentation, I don't have to tell this audience that. And being thoughtful about trying to make a successful outcome for the student and a successful outcome for the institution that also minimizes their legal exposure. So that's the end of our hypotheticals. I did see a number of questions in the Q&A. And Allison, one of the things that I need to ask you, because you know more about the regulations certainly than I do, I was under the impression that the regulations themselves require a refrigerator and access to running water in the lactation room. Is that correct?
I should clarify the refrigerator and running water. So that's really that's under New York law. And so that was for our New York colleges and institutions. However, we expect eventually the regulations will move to include that. And they do discuss that in their notes, but I should have been more clear there. There is not at this time a refrigerator and running water requirement in the room. Although we also expect that since students and employees might be using similar rooms, it's often best practice to have a refrigerator and running water nearby. But I would like to clarify that is under the current regs, that is not required. Okay,
thanks. Jane, do you want to try some of these questions, or how would you like to handle this?
Why don't we, sure. Let's see. Right. Here's a question that I've talked about with with clients. Does a school have to allow Zoom presence in an in-person class for an entire semester because of pregnancy without any specific medical conditions? Again, you know, there's some facts here. There may be additional facts. Start with the in-person class. You know, that's something that I know a lot of people, I've heard from clients, students want you to create an online class so that they can do it with whatever their condition is. And I think there's also some feeling among administrators, which may be correct, that there are some people who just want to go do things online, whatever their medical condition. But any decision about whether someone can should be allowed to participate in an in-person class by Zoom, there really should be sort of, what is the class? I mean, if it's, you know, if it's a wet lab, that seems pretty hard to do. You certainly can't make conditions for doing experiments, you know, of most of these, you know, the kind of equipment you would need, et cetera. Or there might be fine arts classes and others where really the in-person experience is, you know, necessary for at least a significant part of the class. So there would have to be some consideration of what is the class, and you know, what sort of, that's the first part of the question. A request for that kind of an accommodation because of pregnancy without any specific medical conditions, I don't see the logical, that this would logically follow that just because you are pregnant, you need to take a class online. I mean, I think that it would be appropriate to ask for specificity, medical, a medical report from a physician. There may be reasons that this person doesn't really want to disclose that are very, very personal. But nonetheless, I think, I know that OCR is very concerned that schools not sort of, drill down with unnecessary questions. But this seems to me, without more information, why should someone be able to do an online class? And again, if there's a confidentiality issue, of course, I think all institutions know that they have to treat individuals, students or faculty members or others, medical information with the utmost confidentiality, and that it's only shared on a need-to-know basis, and there really has to be great discretion around that. So maybe some of those assurances could help. Barbara, do you have other thoughts about this?
No, I think I agree with what you said. I'd actually like to go on to a couple more questions because time is getting very short. Chris Cruz, who's one of our associates at Bond, answered one of the questions for us, which was, thank you, Chris. He said the definition of medical, this was with respect to the IVF question, whether IVF is covered, because obviously the person isn't pregnant yet if they're undergoing IVF. And he says the definition of medical conditions related to pregnancy includes infertility. So that sounds very much like IVF would be included in this definition. There's another question, a little bit different from the one Jane answered, but on the same wavelength. If a class is not online and a student would like to maintain their active student status, but due to pregnancy cannot, would the school be responsible for creating the online course? Now, I'm going to say no, but you need to go through a process of thinking it through. Did you have an online version of the course, maybe during COVID or recently? And there's just been a decision to transfer the type of teaching to on campus rather than online. And are there pedagogical reasons for that? Again, process is incredibly important. And if the final decision is no, for these reasons, we are not going to create an online course for this particular student, then you've gone through a process of analysis, and that is incredibly important.
Yeah, this one is I've gotten several of this question, particularly where someone wants a creation of a course. So that does certainly come up. I have to admit, I should know the answer to this and I'm not remembering it. Another question is, in a law school program, how does the accommodation process apply, sort of absenteeism relate to verified hours in the classroom setting requirement? And I should know the answer to that, but I think we need to sort of look at the ABA rules together, and I am not remembering how disability accommodations fit in with that, because I think it would be very surprising if there were requirements that precluded certain kinds of accommodations. So I would need to look back into that issue with that disability lens. That there had been the questions I was asked about it before dealt with different issues. So whoever's asking this or wants to know, please email me and I'll do some looking at the ABA regulations and we can discuss.
Okay, it's pretty much time to say goodbye. Please do email any of the three of us if you have other concerns or questions.
Thank you, everybody.
Thank you.